Thank you. Justice Thomas? Justice Sotomayor?
You spent a lot of time on standing, more than I would have hoped. But I do want to say that whether he runs for president or Senate, how do you eliminate that if he doesn't get to run for president, that he'll run for Senate, given that he has a committee with $50,000? I don't want you to spend
I'm
a
so
lot
glad
of
you
time.
asked. So I don't think there's any realistic chance that he's running for Senate. There's a sitting Republican senator who's currently in that seat, who's running for re-election. It's in 2026, and he is likely to win. I think he's likely to win. If he wins, he's going to be the sitting incumbent. It's extremely unlikely that he's running for Senate. The vice president has never said since becoming vice president that he's considering running for Senate. On the $50,000 question, look at it in context. Real Senate candidates would be way beyond $50,000. I think Mark Kelly, who's running for Senate in Arizona, has raised $9+ million. John Fetterman, who's running for Senate in 2028 in Pennsylvania, $1.2+ million. So $50,000 is actually a sign that he's not a real candidate for Senate.
All right, now let's go back to the merits.
Sure.
All right. Justice Kavanaugh said there are 3 prophylactics: the bribery statute, the earmarking statute, and what was the third? Now I've forgotten.
Disclosure.
Disclosure, thank you. McCutcheon seemed to say that those were enough. Why is this different?
I don't think McCutcheon said that they were enough, but I think the key thing to realize, there's some language in McCutcheon talking about conduits and independent actors. I think it's a crucial point for this court to appreciate that there's an internal contradiction in the arguments that the Solicitor General's office is making together with petitioners. They want you to believe 2 things that are diametrically opposed. On the one hand, the whole theory for giving parties special treatment is because, and why parties can't corrupt candidates, is because they are inextricably intertwined. That's the language that comes out of this court's case law that the Solicitor General really emphasizes over and over again in their brief. The parties and the candidates inextricably intertwined. But then we get to talk about quid pro quo corruption. What's their theory there? Their theory there is, oh, these are independent actors, totally different actors, and that's why we don't have to worry about quid pro quo corruption. Well, they can't have it both ways. If the parties are inextricably intertwined for purposes of getting special rights, they can't be totally independent actors for purposes of dismissing concerns about quid pro quo corruption. And I think that sort of gets to the heart of it. I think when you look at McCutcheon relied on the validity of this provision, and I think it's perfectly fair to say that just as in McCutcheon we treated this provision as valid, we're going to continue treating it as valid in this case.
What about Mr. Francisco pointed to the fact that there was no evidence of a quid pro quo involving coordination between a party and a candidate. And he points to the fact that there is no such, that coordination is permitted in 28 states. How do you address that?
So I wasn't part of developing the record in this case. I just think 2 comments. First of all, I think that when you see it's raining out and you see there's a good reason to carry an umbrella, that's a pretty good reason to take the umbrella. And
we're both borrowing from my sister, Ruth Bader Ginsburg.
Absolutely. And I think the Watergate evidence was directly on point. I think you raised it earlier. The dairy industry evidence showed that there was a very serious quid pro quo corruption problem where donors were using political parties to launder millions of dollars essentially to candidates in order to get bribes. So I think that justifies the law. That frankly should be enough. Now, the implicit premise in my friend's position is that once you have a law that's been in place for a long time that's doing good work, you have to kind of continually reevaluate it. And the way you continually reevaluate it is by looking to whether states need similar laws in their states. I just think that's a very bizarre way to think about the problem. And I think the state's brief supporting us makes that clear.